New Jersey is running scared when it comes to their new crazy law that makes it harder to conceal carry than it should under NYSERPA versus Bruen. Let me give you the proof that New Jersey is scared to death they're about to get spanked yet again when it comes to their new gun control laws. Stay tuned. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gunner, constitutional attorney, member of the United States Supreme Court Bar, and New York Times best-selling author. If you haven't subscribed to the Four Boxes Diner Second Amendment channel, please do so. Show your love for the right to keep and bear arms and help us get to 100,000 subscribers. We're working hard to hit that number to help us with the social media algorithms. Okay, so I've gotten a lot of questions about what has just gone on in the state of New Jersey. To bring you up to speed, New Jersey passed a bunch of crazy laws involving sensitive places and rules associated with concealed carry in response to NYSERPA versus Bruen, saying that New Jersey has to start issuing carry permits to law-abiding Americans, which is the rule and the law and the Second Amendment. Now, of course, multiple lawsuits were filed in New Jersey in federal court, and they've now been consolidated in front of Judge Bum, a Bush appointee, by the way, who has already entered a temporary restraining order pending a preliminary injunction hearing, saying that most of these anti-gun concealed carry type laws enacted by New Jersey are unconstitutional under the Second Amendment. A very favorable ruling. And two cases are pending in front of Judge Bum now. One involving the Second Amendment Foundation Firearms Policy Coalition, Coalition of New Jersey Firearm Owners, and the New Jersey Second Amendment Society. That is the lawsuit, and there's some other plaintiffs involved as well. In this lawsuit, this was originally in front of Judge Bum, and she's the one that entered the order in that case against the state of New Jersey. And I'm going to tell you what's just happened, which is a very good sign that we're winning down there. The lawsuit, there's a second lawsuit brought by the Association of New Jersey Rifle and Pistol Association. That's the Association of the New Jersey Rifle and Pistol Association, run by Scott Bach, the president there, with attorney Dan Schmutter. And in that lawsuit was consolidated or transferred over to Judge Bum. So now Judge Bum has both lawsuits challenging these New Jersey concealed carry laws. Judge Bum has already entered an order in our favor, supporting the Second Amendment and against the state of New Jersey. So what has just taken place that shows that New Jersey is running scared? Well, in addition to the fact that they've already been spanked by one major court order, in my hand I have a motion to intervene in the New Jersey case in front of Judge Bum on behalf of the New Jersey Senate President, Nicholas Scutari, and New Jersey Assembly Speaker, Craig Coughlin. Now, what's interesting is I see no purpose in this motion to intervene unless they're scared. I'll tell you why. Historically, when a legislative body or legislators decide to intervene in a pending lawsuit, which means they want to participate directly in the case, it's because they're scared that their rights or their arguments or the law they enacted, whatever it is not being properly defended. Let me give you the classic example so you understand the issue, and then we'll go back to the New Jersey case and what I think it means. The classic example where state legislators seek to intervene to defend a law is where the legislative body is controlled by one political party, which is different than, let's say, the governor and maybe the state attorney general that is controlled by a separate political party. Let me give you like an example. So in a place like California, we'll do hypothetically, but it illustrates the point, it happens all the time. Let's say you have a situation back in the day when California had more than one party. You had a California Republican legislature that enacted a law that, let's say, restricted public welfare benefits to illegal aliens, illegal immigrants. Okay? So the Republican-led legislature, and again, I'm giving this as a hypothetical because you're going to get the point. So the Republican legislature in California, let's say, back in the day, enacts a law that says if you're in the United States illegally, right, and you try to get from the state of California public welfare benefits, you're not allowed them. Because you're not an American citizen, you're not a Californian, we're not going to pay for you. That's totally unfair. So let's say the Republican legislature enacts that law. And then you have a Democrat governor vetoes the law because he disagrees with it. But then the Republican-led legislature overrides the veto and makes it the law of California anyway. Well, the Democratic governor is now mad because it was a law he disagreed with and didn't think should exist. And let's say you also have a Democratic attorney general that supports the governor. So you see the tension here. So the Republican-led legislature passes a law, in my hypothetical, that says illegal aliens, illegal immigrants cannot have public benefits paid for by the state of California because it's not fair. The Democratic governor and the Democratic attorney general disagree with the law, but here's the kicker. When that law is sued over by interest groups that support illegal immigrants, illegal aliens, claiming it's unconstitutional or whatever, the job to defend that state law falls, of course, to the state attorney general. But as you can see in the dynamic I just set up, the state attorney general is a Democrat that opposed the law, and the governor opposed the law as the leader of the executive branch. So you have the Republican legislation going into court being challenged by interest groups that don't agree with it, and that law is being defended by a Democratic attorney general and a Democratic governor who disagree with the law. So in that scenario, it is conceivable that the Democratic attorney general and the Democratic governor may not work that hard to defend the law because they actually want the law to fail. In such a scenario where there's a suggestion or implication that the people defending the law are not going to do an adequate job representing the law and the interest the law represents, it is sometimes possible for the state legislature or legislators within that body to move to intervene to say, look, we don't feel confident that the governor is going to defend our law or that the attorney general is going to defend the law adequately because they don't agree with it. They're on the record disagreeing with it. And we can't trust that they're going to make all the right arguments necessary to defend our interests, defend the law, and uphold it. So we want to hire our own lawyers as the state legislature. We want to hire our own lawyers and bring them in to make sure that all the arguments are being advanced that need to be advanced. So that's a dynamic you sometimes will see on certain legislation, where the executive branch and the attorney general won't defend the law adequately because they disagree with it, and a state legislative body may step in with their own lawyers to try to defend the law on the grounds to make sure it's adequately defended in court against a challenge. That's the classic example. But here's the weird thing about New Jersey. New Jersey, right? New Jersey is basically a one-party state when it comes to, like, they all hate guns. Not everyone, of course. There's some that don't. But the point is, when it comes to the political elites of New Jersey, well, guess what? They're all anti-gun. The governor doesn't like guns. I'm sure the attorney general doesn't like guns. That's my guess. I don't know about the attorney general, but I'm guessing that's the case, to be the attorney general of, in New Jersey in the Democratic world. So, you know, you basically have the legislature has enacted these gun control laws. The governor signed them. The attorney general, I presume, supports them. So they're all aligned in defending these laws against legal challenges. So is there a motion to intervene on behalf of state legislators, these two in particular, to intervene when the interests are aligned of the governor, the attorney general, and the state legislature? The interests are all the same. They all want the law to be sustained, I believe, and not be upheld and challenged by the Second Amendment proponents to fail. That's my guess, right? That's the idea. So this motion to intervene comes, and really they don't explain in any respect why they think the attorney, now maybe they think the attorney general is not very good. Why? Because I don't know if the attorney general is doing a great job and making all the arguments. Why intervene? So either it seems to me they're concerned that the attorney general is not interested in defending the law, which doesn't seem to make sense, or they're arguing the attorney general's office is not competent, which I've seen no evidence that they're not competent, they're not making the right arguments, or something else is going on here. But whatever it is, these state legislators in New Jersey must be scared to death that their legislation, their prize legislation, that gun control legislation is about to get destroyed in federal court, because that's all the indications. And now they're trying to come to the rescue. But here's the reality of it. If I were a federal judge, I would ask them point blank, well, what arguments do you intend to make, New Jersey state legislators, that the attorney general is not going to make? Because I'm not going to let you intervene in this case just so you can add in more pages of documents. You want to submit an amicus brief or something, maybe that's fine. But why do you need to be in this case? If your interests are aligned with the people defending the lawsuit already, you're not going to make any new arguments that I'm aware of, right? So I would be like, no, I don't want, why do you need to be intervening in this case? What is the role of you if everyone is fighting the law consistently? So the fact is, there must be something going on in the state legislature, and I have a feeling this, if you ask me to speculate, here's what I think is going on. Here's my guess. The New Jersey legislators here push this law through, claiming this did not violate the Second Amendment. Well, that already appears to be totally wrong, right? We already have a federal court decision, Judge Bum, in New Jersey, has entered a temporary restraining order basically saying that the new New Jersey gun control laws enacted after Bruen are unconstitutional under the Second Amendment. They watched this channel, they would have known that too, by the way. But nevertheless, they need a federal judge to tell them, understandable. So now, of course, I think the legislator is like, oh crap, we told everyone we could get this through, we could make this happen. We spent all this time and money with all these like anti-gun groups, I'm sure, all this sort of intellectual giants, supposedly with fancy credentials. Of course, they've now apparently run into a buzzsaw in court. And now they're like, oh my God, we need to get in there to defend their interest. And the only interest that I can see these New Jersey legislators wanting to defend, in my opinion, is their reputations. Their reputations. Because the law that they spent all this time and effort crafting, in my view, was unconstitutional. And now you're going to have federal courts tell them exactly that. Say, hey, thanks for spending a lot of time crafting these laws, but the truth is it's clearly unconstitutional and unenforceable under the Second Amendment and the Supreme Court's decision in Nyserba versus Bruen. So I have a feeling this motion to intervene may very well be an attempt to save the reputation of the people seeking to intervene, because again, I see no other reason for them to do that, given the fact that their interests are already being adequately represented, as best as I can tell, by the state of New Jersey's Attorney General and the governor's office and so on and so on and so on. Nevertheless, I'll keep you informed. I think this motion to intervene is a sign of weakness. I repeat, it's a sign of weakness on the part of the anti-gunners in the state of New Jersey, because obviously they feel that the cavalry needs to come to the rescue to try to save this law. And I don't think it's going to work, because at the end of the day, the Second Amendment, New Jerseyites, I hate to break it to you, New Jersey elites, political elites, the Second Amendment trumps the views of New Jersey's political elites. And I'm looking forward to the victorious wins out there by the organizations in New Jersey and their excellent counsel. And we'll keep you abreast as the developments occur in the state of New Jersey involving the Second Amendment and these gun law challenges. Okay, hope you learned a little bit something here at the Four Boxes Diner. If you haven't subscribed, please do so. And we'll see you again here at the Four Boxes Diner.
Orders up. Table 2A.